Arbitration is a dispute resolution mechanism that is designed to dissipate conflict between parties. If we look at the Arbitration Act 42 of 1965 defines arbitration as a written agreement between parties involving the use of two or more arbitrators, as well as there can be two or more parties as well to the dispute, resulting in the arbitrators presiding over a dispute that is currently taking place or a dispute that could essentially happen in the near future. In practice, currently we are seeing that arbitration is taking on a more informal process. And this is really fantastic and welcoming, especially in the South African jurisdiction where we have always known litigation to be the forefront of resolving dispute. So I think this is a very fantastic welcome, especially in the area of alternate dispute resolution. Parties sometimes do not always have a choice between arbitration and approaching a court of law. And what this means is simply that the Arbitration Act is very specific, whereas it excludes matrimonial matters. And that means these matters specifically have to go to a court of law. Whereas with regard to labor legislation, we find that arbitration is at the forefront of resolving labor disputes. If we look at labor disputes, they usually take the avenue of going the procedure of the CCMA. So that is conciliation, mediation, and arbitration. Parties don't usually have a choice between a court of law and arbitration sometimes. We find that in certain instances, parties cannot approach a court of law once arbitration proceedings have commenced. So when two parties have already decided on arbitration and the arbitrators have commenced, this arbitration needs to come to an end before a court of law may be approached. Arbitrators do not have the power to actually enforce an arbitration award, and therefore arbitrators would have to approach a court of law to enforce an arbitration award, as well as parties if they find that they need to decide or they need to find out about the validity of the arbitration agreement. They can always approach a court of law with regard to this, and even if they find that they want the arbitration agreement to be reviewed, they can always use a court of law in this instance. The procedure of arbitration is usually quite simple and flexible. We find that South Africa has welcomed arbitration as a fundamental forefront of alternate dispute resolution. So let's quickly talk about the procedure. The procedure, like I've mentioned, is simple, it's flexible, and it is usually contained in the written agreement between the parties. So the parties will decide on the procedure and the process that would happen in the arbitration proceeding, which is usually documented in that arbitration agreement. The arbitrator is the one that has a lot of power in the arbitration proceeding. And if we look at Section 14, subsection 2 of the Arbitration Act, this specifically empowers the arbitrator to call witnesses, to examine documents, to examine evidence put before it, and to make sure that all parties to the dispute are there to give evidence with regard to finalizing the dispute between the parties. The presiding officer of an arbitration agreement is usually decided upon very early in the arbitration. And this we find is that if parties have consented or reached consensus with regard to the arbitrator, this would be mentioned in the agreement between the parties. However, if parties cannot decide with regard to who the arbitrator would be, they can nominate or appoint an independent body or another person to make that decision for them. The arbitration agreement can also specify that a particular type of arbitrator would need to be utilized. For example, if the matter were to be dealing with, for example, an engineering contract, they would need to utilize an arbitrator that would have engineering law experience. So that actual arbitrator would need to be specified in the written agreement with regard to expertise and knowledge. And for example, parties could also decide that they would be more preferred to having an arbitrator with maybe 10 or 12 years of experience. The time frame of arbitration is one that is, I think, the greatest advantage. Arbitration is a mechanism that is supposed to be quick, fluid, and effortless. And if we look in current practice, arbitration would actually be decided upon with regard to what the parties decide, again in that written agreement. So the written agreement has a lot of information that would determine how this arbitration proceeding would be carried on. For example, parties can decide that they would use arbitration for a period of 3 to 4 months. And if they don't find any success, or the parties find that arbitration is not working for them, then they can decide to maybe, use a court of law, or maybe to use another alternate dispute resolution mechanism. But the time frame of arbitration is usually quick, and the turnaround time is speedily. So that is the purpose of alternate dispute resolution, is to ensure that parties can dissipate their disagreements very quickly and very efficiently. The cost of arbitration is one that becomes slightly tricky. If the parties have decided that they are going to utilize a specific arbitrator, and that person's name has been cited in the arbitration agreement, they then can approach that arbitrator well in advance and have a recommendation or a suggestion from that arbitrator what they would actually charge as a day rate or an hourly rate to carry out that arbitration proceeding. But the usual costs involved in an arbitration proceeding would be the payment to the arbitrator, if parties have decided to use a venue, if there's catering involved, as well as if there are any expert witnesses that have been called in the matter to adduce evidence. All these parties would need to be paid. So at the outset of the arbitration agreement, it is very important that parties consider the costs involved in arbitration, and these costs would have to be borne by the parties. Arbitration, like I've said, is an alternate dispute resolution mechanism. And what this means is that arbitration is a very confidential setting, and it is very private. So the parties to the arbitration, as well as the witnesses, are the only parties that would actually be involved in the arbitration process and procedure. This makes for a wonderful welcome again for the fact that parties can rely on confidentiality, and the fact that these proceedings are not public in nature, and they will obviously have the element of privacy in them. Arbitration proceedings are not subject to an appeal and only subject to a review. This basically means that it has a higher standard as opposed to litigation, because in litigation we find that judgments usually can be reviewed and go on appeal. It has been expressed that arbitrators are usually more expensive. And I think what this actually means in practice is that arbitrators have a lot of experience, exposure, and expertise in their particular area